She keeps having her friend, Mary Perry, go and make minute orders to affect things that affect me. So I'm kind of sick of that.
Case number 8-20-D. Council and parties state your appearance for the record, please.
Amanda Roberts, bar number 9294, on behalf of I'm asking that you waive her appearance for the discovery motion. Thank you.
Mr.
Hey, good afternoon.
State your appearance for the record, please.
Okay. Defendant.
Can you please remove your hat, sir? Thank you. I know you know better than to appear that way in court, Mr. This is plaintiff's motion for a protective order. Ms. Roberts, have you seen the opposition that was filed yesterday?
I did, Your Honor. I have it. I reviewed it this morning.
Okay. Just wanted to make sure everybody was up to speed. Before I entertain argument, I do remind everyone that under EDCR 5.218, the court is not to tolerate attacks on opposing counsel. Please limit your argument to the merits of the motion, not the person making the motion. It is inappropriate in your moving papers or opposition. It's also inappropriate in oral argument. Please go ahead, Ms. Roberts.
Thank you, Your Honor. So this matter, Your Honor, before the court, following the Supreme Court matter, the trial occurred December 20th of 2021, and the findings of fact, conclusion of law were filed December 23rd of 2021. Thereafter, the matter went up on appeal, and the Supreme Court heard the matter, and on September 16th of 2021, they issued an order affirming in part, reversing in part, and remanding. Specifically, what was left up to the district court judge relates to setting child support based upon Mr. income, as my client was awarded custody, primary physical custody, and sole legal custody of the children, and to look at the factors related to Mr. income pertaining to spousal support. Thereafter, Mr. counsel at the time filed for rehearing, which was denied, and then it took some time for remitter to come down, and we received a minute order on January 19th of this year that indicated that it was brought to the court's attention that the remitter had not been properly issued, so the evidentiary hearing was continued except for April 21st in this matter, and the order specifically says that discovery is open related specifically to defendant's income only. So I saw Mr. moving papers or his opposition that he argued about the fact that was never taken before trial in this matter. So I had to go back and pull everything to figure out what happened. Does the court want me to go over all of the timeline of that with the court, or just address the NRCP 16.21 arguments?
Happy to hear your arguments, counsel.
Okay, so as far as Your Honor, this was when discovery was open before the trial, which occurred again December 20th of 2021. He noticed the deposition May 21st of 21. On June 9th of 21, my office notified him that I was in trial specifically and provided him alternative dates for the deposition, as well as asked him how we were going to address the protocol for the extended order of protection that was in place. June 10th, he responded and indicated that he saw the trials had previously been rescheduled and he was not going to reset the deposition. So he set a discovery dispute conference that was noticed on him June 11th. He did not attend or participate, and that was set for the 14th. On June 14th, we then sent him a letter indicating again that we had set the discovery dispute conference. We would file a motion if we couldn't resolve the matter, giving him alternative dates and talking about protocols for the deposition given the extended order of protection. Then on the 21st, because he had brought up the trials previously scheduled and the conflict, I notified him that that trial was moving forward and I was not available to attend the deposition. He did not follow up with me regarding that matter, as I can see anything in the file. As it relates to NRCP 16.21, subsection B1, which he cites, B1 specifically says that it relates to something being open post-judgment custody matters. This is not a post-judgment custody matter. So that means that the only thing that would be applicable is 16.1B2, which says that on motion or by order of the court, that post-judgment discovery may be applicable. So in this matter, the court has already addressed the post-judgment discovery and indicated that it is in relation to defendant's income. So taking my client's deposition is not going to have any bearing on what Mr. income is. So we don't believe it's appropriate for the deposition to go forward.
Thank you, counsel.
Yeah, so just a few points. Going back to where she's saying about the first deposition that was scheduled. I've read the case law, all that on it. It's not on me to go and say, oh, hey, let's move it to this date. If she wanted to file a motion, it's on her to file a motion. She didn't do so. If we go to this, I've read all the case law. I've read the simple rules of procedure and all that. It's not a matter of if it's coming back to set custody. It's on if it involves custody, then those matters come back and the discovery is automatically reopened. I read the committee notes and all that. So,
Mr. decided to enter CP 16.205, but I don't believe that this is a paternity action, is it?
hold on, let me see what. I don't remember which part that would be.
Is it a paternity action or is it not?
No, it's just child custody, but
It's a divorce. It was a divorce action, right?
divorce with custody. Yeah, maybe I put the wrong number in there. I don't remember, but basically the rule says it automatically reopens for discovery on that. She keeps saying that, oh, the judge made a minute order. The minute order doesn't apply. We've had this conversation many times before about you can't make a minute order over anything that's not just administrative. She keeps having her friend, Mary Perry, go and make minute orders to affect things that affect me. So I'm kind of sick of that. But beyond that, this also goes to alimony. The first subsection of NRS 125.150, when you look at alimony, financial situation of both parties. They're not looking at it statically as what it was back then, it's what it is now. So I'd say it does come into account.
Point to me to the portion of the Supreme Court's order where it suggests that alimony is going to be an issue in the remaining district court action.
That's what they said. She had to make decisions on her. That's the second part of it. It's the alimony is what got sent back along with child support.
Can you point to a page and read to me that section?
It's the portion where it says she needs to make decisions about. I don't know, Amanda. You can say what it is, but that.
No, I'm asking you, counsel.
Well, I don't have the freaking paper in front of me. Hold on.
I suppose I shouldn't call you counsel at this point.
Yeah, I don't have the paper in front of me, but that's what the second portion of it is. Those are the parts that came back were alimony and child support.
Ms. Roberts, do you have any reason to disagree with that argument?
So, as it relates to the alimony, Your Honor, the Supreme Court found that the issues regarding my client's income were already on the record, and there were findings made pertaining to that. The only part that was not before, or that had not been factual findings related to respondent spousal support, or Mr. spousal support, and that's why the court limited it. My client had already testified, and the findings of fact and conclusions of law in the case were very extensive, Your Honor, 32 pages. And so Mr. was not at trial at the time. That was ruled upon by the Supreme Court. The Supreme Court said that that was not an issue that they were going to, that he was not going to prevail on, and that the court properly moved forward with the trial. And so that was already a portion of the trial. That's why the only thing relevant was Mr. information, because he had not essentially provided it. At the time, Mr. was still a licensed attorney, but was temporarily suspended from the practice of law, I believe temporarily at that point. And so the judge in the decision at the findings of fact, conclusions of law, made some kind of imputation of his income based upon what her understanding, not based upon a request that we made, but based upon an imputation of what she believed he could make as a law clerk. And so the Supreme Court found that that's not sufficient. She has to specifically look at, as it relates to it, his financial abilities at the time, which have changed since then, as the court noted just a second ago. So that's why his information is relevant, but she had already ruled on the issues pertaining.
And I would just like.
I interrupted your flow to ask your question, so please proceed.
I was just going to say, I'd like to add that I don't think they specifically made findings of fact of income and all that, but also Ms. Roberts said mine has changed since then, so they need to find out mine. I'd also like to point out that under the alimony statute, Mrs. has changed since then, so it's not a static issue. So it's something that is keep ongoing, and I'm entitled to discover it. So.
Last word, Ms. Roberts.
Just that the minutes order is very specific. That's been issued by the court, Your Honor. It specifically says that the court is reopening only as to the defendant's income. And we're not going, taking my client's deposition is going to have no bearing on what the defendant's income is.
That's my problem, Mr. is that even if I buy into your argument, I would have to be changing what I believe to be the decision of the district court.
What decision of the district court are you talking about?
Decision as memorialized in the minute order. And I understand your argument with regard to the effect. Please don't interrupt me.
Well,
I understand your argument with regard to the effect of the minute order.
Yeah, because it's not effective. So how are we saying we're going to follow it?
I understand that. Still, the judge's indication as to what she believes the proper scope of discovery is in this case.
Which is not enforceable.
If you go get the district court judge to change...
Well, she's not going to be on the case much longer, I don't believe, so...
Well, that's fine. Okay. Can I finish, please?
Sure, go ahead.
Oh, thank you.
Oh, you're welcome.
If you can get her to change her indication as to the scope of discovery, then taking your ex-wife's deposition may be appropriate. Until then, it's not. I'm granting the motion. Ms. Roberts, please prepare the report and recommendation. Run that past Mr. The record should reflect that he's removed himself from the video session. Please present that to him for approval as to form and content. We need that returned to the court within 14 days to avoid a sanction. We will set a status hearing on March the 8th at 1:30 p.m. to determine if that's been accomplished. If it has, there will be no need to appear. Do you have any questions, counsel?